Hello, my name is Craig Warren. I'm 71 years old and I'm sort of retired. I retired at 65 to provide full-time care for my wife who's had some serious health issues. But I realized recently that I need something to do to keep my mind active. So why not a podcast? I have a lot of experience in different areas. I definitely have a lot of opinions, so what more would you need, right? I should mention here, too, that I have never been a member of a political party, nor do I intend to be. I'm in the George Washington camp on this one. He warned us about the dangers of the party system. If you're interested, you can Google George Washington's farewell address to Congress. Farewell address to Congress. You might be surprised. He had a lot to say about other things than the political party system. It's good reading. Every high school student in the country should have to read that, I think. Okay, first up today is, I guess you'd call it politics. What I want to talk about is the court system. Our court system seems to be encroaching on the other branches of government consistently. I know there are some that view that as a good thing, especially if you have found that filing a lawsuit in some liberal court gets you what you want. The wishes and the wants of the general public be damned on this one, I think. So let's start at the beginning. Let's go through and review what our founding fathers envisioned the court system to be, specifically the federal court system. And, of course, this would include a lot of the state Supreme Courts and things, too, but specifically the federal courts right here. The courts they created were to provide guidance on constitutional matters. They had no authority to override our elected officials. Their duty was to provide a judgment only. Not only was that the intent, but they warned us many times about what would happen should the judiciary overstep their bounds. And that's my focus for this podcast, or at least the first part of it. I'd like to first go back and give you some information and direct quotes from our founding fathers on their intentions, followed by their concerns, predictions, and warnings. First up, there are some very important quotes that were given by a lot of our founders as a definition or defining what the judiciary's role is. They envisioned the judiciary as an important part of the federal government. They intended for the courts to serve as a check on the legislative and executive branches, ensuring that the government, their actions remain within constitutional bounds. They established these checks and balances within the government to ensure that no single branch could dominate the others, thereby protecting individual liberty and preventing the concentration of power. And that's an important part. I've highlighted this in red because lately you've seen that we have one particular branch, the judiciary, pretty much overriding the other two branches of government. And I'm certain this was not the way it was intended. Let's go through a couple of these quotes. Alexander Hamilton in the Federalist Papers, number 78, described the judiciary as follows. He viewed them as the least dangerous branch because it possesses neither force nor will, but merely judgment. That's an important distinction. They intended the courts to make decisions, but rely on the other branches to enforce it. They acknowledged the courts while emphasizing the role in upholding the Constitution. The judiciary's function was to act as an arbiter, preventing the legislative branch from overreaching their duties and also the executive branch from overstepping their bounds. Thomas Jefferson also warned us against the dangers of consolidating power, particularly within the federal judiciary. Jefferson was concerned that such centralization would erode states' rights and lead to widespread corruption, disrupting the balance that is designed to exist between the state and the federal authorities. Jefferson believed that this consolidation of power at the federal level, especially in the judiciary, would create a scenario where states could no longer exercise their sovereignty. That in turn would shift the balance of power in favor of the authoritarian central government, namely the federal government. And he argued that a strong central authority could become disconnected with the needs and the rights of the people and the states, potentially leading to policies that favored federal over states. I'm sure you haven't heard of anything like that, right? So he's seen this stuff coming, and so we have to constantly be vigilant of it. And more specifically, the founders, as can be read in James Madison, Notes of the Debate of the Federal Convention in 1787. He wrote, and he expressed concerns that the federal judges might become like the judiciary of Aragon, who by striking down laws and imposing their own policy preferences upon the people became by degrees the lawmaker. See, he was afraid that they would be exercising or claiming rights that belong to the legislative branch and even to the executive branch. Now, I want to go back through this the judiciary of Aragon. And Aragon is not a place in Lord of the Rings, just so you know. It was a kingdom that was started in somewhere around 1100 AD, from what I can find out. It lasted for a few hundred years. And it's in at least part of what is now modern Spain. This Aragon was a kingdom, because it had a king, but they also had a form of government similar to what we have now, in the fact that they had a parliament, and they also had this Justicia de Aragon, which would be like our Supreme Court or our justice system. The problem is they, at that time, they extended a certain amount of executive powers to this office because they allowed him to be the one who would swear in new monarchs when that time came and new members of parliament, those kind of things. But over the years, they kind of gradually grabbed up authority from both the other branches. And at one point, it became so much so that they could veto any action by any official, including the king himself. And I don't think we're too far away from that right now, to be honest with you. That's why he listed this. Our founding fathers were very students of history. They didn't just kamikaze and cobble some government together. They had researched governments from over the last 2,000 years, recorded history, from great dynasties and kingdoms and empires, whatever you want to call them. So they picked and chose things from some of them so that they thought they could put forth the best form of government that they could possibly do. So I guess my question is, some of the stuff we've discussed, are any of you seeing any of the concerns playing out in our country today? Not only at the national, but the state, county, and city levels. It seems like the only things that get done, or rather can get done, is by lawsuit and some judge's judgment, ordering our elected officials to do something or not to do something. Now, these things have to be instituted by lawsuit. But what happens when judges decide they no longer need that step? They only need to see a problem, or at least what they believe is a problem, and they decide to do it all on their own. They decide how to fix it. I mean, our other branches of government are becoming more relevant every day because of these lawsuits and the judges' decisions. And I have one example here recently. This is very similar to what I'm talking about. Remember back, I'm not sure what year it was, but it was 2019 probably, when New York sued Trump. They claimed damages, but they had no injured party, right? They had no actual real plaintiff. It was just the attorneys, the attorney general or whatever that was filing the lawsuit. So they decided, they found where Trump, they accused him of inflating the value of a piece of real estate in New York, and he used that as collateral for a loan. and they say that he committed fraud because he did. Well, no. The thing is, you have to understand, in a court like this, the state shouldn't be just able to bring charges against somebody for something without a plaintiff. They claim damages. They sued, they gave him a judgment against him for damages of all kinds, but there was no plaintiff. From what I understood and what I read, they actually even tried to get the bank to come in and testify and be a part of it and be a plaintiff, and they, no, dude, we weren't injured in any way. He was never late on a payment. The loan's been paid. We made money. We're not going to do that. So this was just a matter of the courts trying to overstep their bounds again on our legal system. And I see it getting worse if we don't fix it. And whether you like Trump or not, what they did was absolutely a horrible thing. Of course, it was overturned eventually anyway. Everybody knew it would be. But their whole intent wasn't really the lawsuit. It was to try and delay him so he tie up his money so he wouldn't be able to run for president. Our court system should never be involved in the political part, but they are. Okay, this brings me to a point here. I live in Utah, and here recently we have gone through a situation like this, a real prime example of our courts running amok. Recently, the state legislature redrew the voting district boundaries, which is their state constitutional responsibility. And I might add, it is their right and responsible, and nobody else's. The Constitution is perfectly clear that it is the state legislator's job. It's also mentioned in the federal that each state legislature will do this. Okay? But they redrew the maps, and some group wasn't happy, so they used a provision in our state constitution to gather signatures for what's called a ballot initiative or a referendum. The intent was to force the state to create an independent commission to draw up the voting districts. Well, the referendum succeeded and was placed on the ballot and was passed. The problem is that the legislature sued to stop the referendum in the first place on the grounds that it was the only way to change the Constitution was through an amendment process, which is much more involved and much more difficult, and that's done on purpose. And they were absolutely right there, but some judge made a judgment that the referendum could go forward. So then the state legislator, once it passed, the legislator refused to comply with that because they said it was unconstitutional, and they were right. And they reintroduced their original map, and of course that set people off, so they went again, ended up in court again. This time the judge ordered the legislature to draw up a new map, and the one that she liked, or she would choose one on her own. Well, she didn't like the maps they drew up, so she chose one on her own. Of course, the legislators had no choice then but to sue and take it to the state Supreme Court this time. The thing is, our Constitution can only be changed by a constitutional amendment, and a judge who is sworn to uphold that Constitution should know that. This whole mess could have been avoided. The ballot initiative should never have been allowed to go forward, as the legislature argued. Instead, an amendment process should have been started. If it could meet constitutional requirements, then we could have fixed it. But we're in a tremendous mess now. The primary elections are coming up very soon. The voting districts are still in flux. Of course, the legislature has no recourse but to sue and force this to be addressed in the state Supreme Court. Man, if the judges stay within their bounds and follow the Constitution, which they have sworn an oath to defend, this wouldn't happen. My point of view is there's no judge in the world should be powerful enough to override an amendment to the Constitution or create an amendment to the Constitution and to amend an article of the Constitution. This should always be left to the people and go through the proper processes. I remind myself again of what we just read from James Madison. The judiciary, by striking down laws and imposing their own policy preferences upon the people, become by degrees the lawmakers. And that's what we've seen here. I might add, too, that this map that she chose was actually drawn up by a couple of politically motivated activist groups. And she chose their map over our state legislature, which the law gives them the right to do it. I'm not sure how fair that is. Our founding fathers were a lot smarter than we think they are. And we don't give them near enough credit. This issue is only one of many things they warned us about. And many things have come to pass in recent years where we should have listened to them. My last main thought on this issue is on a national level. There's 94 district courts. And in those district courts, there's about 700 district court judges. And I don't see how it makes any sense to anybody that any one of these judges can overrule the President of the United States and or the Congress. These are unelected appointees. Our government was and is and should always be a government of the people, by the people, and for the people. We should always be governed by duly elected representatives, not some appointed bureaucrat. And remember, again, the words of Alexander Hamilton. The judiciary is the least dangerous branch because it possesses neither force nor will, but merely judgment. If we don't get the courts back in line with their constitutional duties and limitations, then our country's lost. Let's face it, we truly have no government today, or at least not a functioning government, but a government by lawsuit and unelected judges. Sounds a lot more like tyranny to me. I have a little bit of an update that just came in later this afternoon, so I've added it here at the bottom. This just goes to another verification that our court systems are broken. The legislatures didn't get this to before the states or the Utah Supreme Court. But here's what happened. They didn't judge this. They made no decision as to the constitutionality of this thing. They didn't rule on the merits of the case. They just ruled on procedural errors. They said the state didn't follow some kind of a procedure, and so they dismissed the case, basically. I just can't figure that out. I don't see how it matters. You have a constitutional issue, and that's your job to fix it. Then this they hurried and got an emergency hearing to a 3-panel judge district court, federal district court. They kicked the can down the road too. I don't know sometimes you just got to step up, be a man, But what they did is they used this argument. Here's what they call the Purcell principle. You've never seen that in the Constitution, right? Because it's not part of the dang Constitution. But this Purcell principle is the idea that federal courts shouldn't change election rules too close to an election because it causes voter confusion. Well, let me tell you a little story. If they would have overruled the judge and put the map back in place that the legislature passed, there wouldn't be any confusion at all. See what this new map does? 2 of our legislators, people going back to Washington, 2 of them now no longer live in the district that they're supposed to represent. They don't even know for sure how they're going to get the people so that people know who they are and where they're at and if they're supposed to vote for them still. Right? So that's confusion. So I have no idea how judges can come up with some of these stupid judgments and things they do. It's just horrible. Anyway, like I said, both of these courts basically kicked down the road because they just wanted to step up and face the truth and do the hard job. Okay, I'm not sure this is over yet, though. I mean, this will and has to end up at the U.S. Supreme Court. I mean, our Constitution is broken now. We have Article 4, which specifically states that the legislature has the authority. The federal also says it's the state's legislature that does this. But now we have this mess, and so we have to fix one way or the other, because you can't have a constitution that's in conflict. We have Article 4 that says no, this is the way it is. We have Article 23 says no, you can't. If you want that, you have to go through the amendment process. It's just stupid. I just don't understand these judges. But I think I've had enough of this for now. So let's move on to something a little lighter note. We'll get back to the court system, I'm sure, in a future podcast, believe me. Anyway, my question is, how many of you out there have been watching the NFL this year? Very much. Anybody watch the Super Bowl? I watched a little bit of it. I definitely did not watch that halftime show, I have to say. I had no interest in that at all. I wouldn't really care about the game that much either this year. I didn't have a dog in the fight, you know what I mean? I didn't really care who won. I mean, it was kind of cool to watch some of it. But one of the reasons I want to talk about this is because I've noticed something in the last year or two. And one of those, well, I've noticed a lot of things about it that bother me, but in particular for this discussion is the offensive and defensive line. I've noticed that the defensive line in a lot of teams, they've kind of slimmed them down a little bit. Have you noticed that? I mean, we have a lot of these defensive tackles and stuff they're big, but don't have the big belly, and they're very fast. You know what I'm saying? And I see this in this game early on, that it's like Seattle did to the Patriots most of the game. I mean, their offensive line couldn't keep them out. Not at all. It was just a terrible showing there. And I see two problems with the way the linemen are working, especially the offensive side. They are bigger, and they're not necessarily stronger, but they're on average slower and less agile from what I can see than their counterparts. And a lot of that, most of them have a big belly, and I just don't think they're in as good a shape. The problem I see with that is because of that, I think we have a lot more quarterback injuries and stuff because the not just because of the sacks, but because of the number of hits, because the defensive backs keep driving all the offensive linemen right into the quarterback. Now, I'd like to address my idea of this thing and say why I think that the offensive should start trimming their guys down, be able to get their guys a little quicker and more agile, real agile, those kind of things. And one of the things, though, is not just that, but it's just that their basic premise of how linemen should work is skewed. And I'm going to rely on physics for this one. Now, mind you, I'm relying on a 7th grade science class for this one, right? Because in that class we learned some very basic principles of physics, like the one that says objects in motion tend to stay in motion. If you notice on pass plays, those big linemen start racing backwards as soon as the ball's snapped. Well, that gives the defense a definite advantage already. Once he's already moving, it doesn't take near as much force or power or strength to keep him moving. And that seemed not to make any sense to me. Once he's moving backwards, physics says it's a lot easier to keep him going backwards. And that brings me to a second principle, but it's basically tied together of these two. And that one says it takes a much greater force to start an object moving than it does to keep it moving. So my solution here is to trim down these offensive guys a little bit, get them more agile, but then let them stand their ground once in a while. Instead of just being like they're in a track race going backwards to collapse in on the quarterback, stand up and actually block these defensive linemen once in a while. I think that would also eliminate the problem of all these stupid false start penalties. Have you noticed? I mean, the offensive linemen, particularly the tackles, because they're the ones they have to sort of this run thing. They have to run backwards, and I don't know. It just seems stupid to me. But I'm just saying, what the heck do I know, right? But that's just something I see that I think that somebody I mean, the defensive linemen used to be these big guys too, but now they're slimming them down a little bit. They're working more on strength and speed instead of just size. Okay, moving on to one last item here. I'm sure you notice in my bio that it says I'm no party affiliation, never will. So I can speak from a neutral position about political things and politicians. Things I find stupid, silly, or sometimes just unexplainable, like this one. According to Glenn Beck, there was a Georgia Senator, John Ossoff, held a political rally recently. Those attending had to provide a government-issued picture ID to enter. But wait a minute, he's a Democrat, and they're against that ID to vote, right? So why would he require a picture ID to go into one of these political rallies? Right? Doesn't make sense to me. I find it kind of hypocritical, to say the least. Voter ID is not discrimination. It's just common sense. By the way, what is really discriminatory about this mess is that I have to show a picture ID to buy a beer. But somebody wants to vote, no big deal. You just walk right in. Doesn't matter who you are or where you came from. I think it has to go under the simply unexplainable category. And don't worry, I picked on Democrats this time, but I'll get around to Republicans later, I'm sure. Well, that's my ramblings for today. I appreciate your time tuning in. I hope you found it entertaining and or enlightening or thought-provoking. So I hope you will check us out in future podcasts. Thank you very much. You guys have a wonderful day.